Well, I'm glad to see that so many of you have wended your way down here on a not very appealing Saturday morning. I thought I might first of all just run through the program for today. We'll be starting with David Rogers' lecture on industrial property, followed by a short coffee break, and then David Kee's lecture on banking and commercial law. That will end at 11 o'clock, and the group discussions will be from 11 until 12:30. Again, I would ask you to go to the same group rooms as you were in yesterday, and the Krempelette group remains in room 234. Yeah. Yes, Mr. Rogers' lecture will be available at this door. If you'll go out that way, the girls will give it to you after this lecture. Now, I'd like to introduce David Rogers to you. David is a graduate of the University of Toronto in chemical engineering and of Osgoode Hall Law School. He was called to the bar in 1959 and is a member of the Association of Professional Engineers of Canada, United States Trademark Association, the International Association for the Protection of Industrial Property, the New York Patent Law Association, and I assume the Law Society of Upper Canada. David has participated in a number of programs, both organized and directed, as well as given lectures in a number of programs for the Law Society, which shows that he is not easily intimidated. I hope that he will be able within the next 45 minutes to make you all instant experts in the law of industrial property. David?
Thank you, Jack. Last night I was rehearsing my talk in the presence of my 3 children, and they were not too impressed. One of them said, "You mean that people are actually coming to listen to this?" In order to impress them, I pointed out that not only were they coming, but they were paying $50 for the privilege. I must say that they found this unbelievable when they considered that last year we paid only about $5 to hear Bill Cosby. I can't promise to be as funny as Bill Cosby, but I may be able to tell you a little more about industrial property law than he could. Most of you probably don't run into industrial property law problems too frequently, but these problems can have a significant effect on your client's business. I think it's important that all lawyers be at least aware when such problems exist. I think this is even more important in the case of the small businessman, because whereas the president of the large corporation probably has had as much experience with industrial property as the average lawyer, the small businessman has not, and he will rely completely on his lawyer. In the time available today, I can't go into any great detail, but what I propose to do is to discuss those problems which, in my experience, are most frequently encountered by the lawyer advising the small businessman. Probably the most common question you will be asked in the field of industrial property are those relating to the method of protection of a new development. There are 4 basic ways that a new development may be protected: by patent, by industrial design registration, by copyright, and by trade secret. When the average businessman thinks of obtaining protection for his development, he will first think of patents, and a patent usually gives the best protection. If properly drafted, a patent will give broad protection and will give that protection for 17 years from the date of issue. The first thing to consider is whether or not the development is proper subject matter for patent protection. This has two aspects. Is it the sort of thing for which a patent will be granted? And is it an obvious improvement over what is already known? It is very difficult to set down any rules as to what are the sort of things which can be patented. On the one hand, there are things such as a method of extracting iron from iron ore, which is clearly good subject matter. On the other hand, there are things such as a new method of high jumping, which clearly is not. The inventor of the Fosbury flip, for example, could not obtain a patent, despite the great originality. In between, there is a gray area where the question is not as clear, and the courts have decided doubtful situations one at a time as they arise and without any clearly expressed principles. In fact, it might be very difficult to say upon what principle a method of extracting iron ore is more proper subject matter than a new method of high jumping. However, in most cases, there will not be any great problem in deciding on the difference. Things such as processes for producing products, machines, chemical compositions, mechanical devices in general are, as a rule, proper subject matter, whereas things such as business systems, methods of treating the human body, and agricultural processes are not. In the case of our indestructible toothbrush, referred to in the factual situation, the plastic from which the toothbrush is made could be patentable, as could the structure of the toothbrush. However, a method of brushing teeth using the toothbrush would not. The genius who invented the method of brushing teeth up and down rather than crosswise no doubt made a very great contribution to dental hygiene. However, he could not patent it, and he never made a nickel from it. In addition to being the sort of thing that is patentable, the development must also be what is usually referred to as unobvious. It is sometimes difficult to distinguish between this question and the question just discussed as to whether it is the sort of thing which can be patented. But there is a very clear distinction between the two questions. A new method of brushing teeth may be the most obvious thing in the world, or the most unobvious thing in the world, but it is not patentable because it is not the sort of thing which can be patented. At the same time, the structure of the toothbrush is precisely the type of thing which can be patented, but it would not be patentable if the structure is considered to be obvious. The question of obviousness is in theory an objective one and is usually stated by asking the question, would the invention have been obvious to one skilled in the art having full knowledge of what is already known? It is sometimes difficult to explain this legal principle to a client who has spent the last 20 years working on his invention in an attic. You often get quite a violent reaction when you say to him, "I'm sorry, Mr. Jones, but that's obvious." And you must be very clear to make it clear to the client that this is a legal term and not your personal opinion. So you'll see that in practice the question is necessarily a subjective one, and different people will have a different view as to what is or is not obvious. But of course, the only view in the long run that really counts is what the Supreme Court of Canada thinks. Apart from whether the invention is good subject matter, most important other thing is to have an understanding of the relevant dates and time limitations relating to the actions of your own client, so that your client does not do anything himself which may prevent him from obtaining a patent. The main problem is the effect of the sale public use or publication of the invention. In Canada, any publication anywhere or any public use or sale in Canada more than 2 years before the actual filing date in Canada would be a bar. And it's important to note that this is the actual filing date and not the convention priority date. Substantially the same applies in the United States, except that the period is 1 year rather than 2 years. Other countries vary from country to country, but the general rule is that any publication anywhere or any public use in that country before the filing date is a bar. In this case, the filing date is the convention priority date and not the actual filing date in that country. Thus, if you file in Canada on June 1st, 1972, and file in England on May 31st, 1973, your English application will be considered to have a filing date of June 1st, 1972, when it was originally filed in Canada, so that you only need to worry about publications before your Canadian filing date. There's also one other statutory bar, which is of some importance, and that is when a patent is issued in another country to your client or as assignor claiming the same invention. For example, where your client is approached by a company in Germany who has a German patent but has never filed in Canada and offers a license under the Canadian rights to your client should be made aware that since the German patent has already issued, it is too late to file in Canada, except in the unlikely event that the application for the German patent was filed less than a year ago. I'd like to conclude the discussion of patents with a brief description of the general procedure followed to obtain patent protection. The first step is to have a discussion with the inventor, and on the basis of this discussion, try to decide whether the invention would likely be patentable, assuming it is new. This involves considering whether it's the sort of thing that's patentable and whether it appears to be an unobvious advance over what the inventor himself knows is the prior art. At this stage, it's also important to consider any statutory bars, such as any prior publications or public uses by the inventor, and whether the inventor has ever obtained any patents himself in other countries. It frequently happens that an inventor who comes from Europe will have already obtained a patent in Europe some years ago before coming to Canada. And in this case, it is of course too late to obtain patent protection in Canada. Also at this stage, you should attempt to make certain that your client is in fact the inventor. And if he is not and merely obtained the invention from someone else, possibly in another country, then he cannot file any patent application without an assignment from the actual inventor or inventors. If it appears that the invention would be patentable if new, the next step is usually to make what is known as a preliminary novelty search to determine whether or not the invention is new. This is done most cheaply and efficiently by making a search in the U.S. Patent Office. If the invention still appears to be patentable, after examining the prior patents located by the searcher, the next step would be to file a patent application. It is usual to file first in one country only, and then decide just prior to the end of the convention year in what other countries protection will be sought. For a Canadian firm, it is usual to file first in Canada or the United States, and it probably doesn't make a great deal of difference in which country you file first. As a general rule, it takes approximately 2 or 3 years from the date of filing for a patent application to issue to patent. Although there's some cases where it can take much longer, and I have one myself right now which was filed in 1953, and still hasn't issued and probably won't issue for a good many years yet, since it's only now started into the courts. Now this has some relevance because the term of the patent in both Canada and the United States is 17 years from the date of issue. So in actual fact, the inventor is not too concerned about getting his patent in a hurry as a rule, and usually prefers to delay it. And it's the government that is constantly trying to get the patent to issue faster in the public interest. In most countries besides Canada and the United States, the term runs from the date of filing rather than the date of issue, and it's usually a term of somewhere from 15 to 20 years from the date of filing. Another difference between Canada and the United States and other countries is that in Canada and the United States, there are no annual renewal fees payable to keep the patent in force, whereas in almost all other countries, it's necessary to pay a fee every year to maintain the patent in force. And these fees increase each year and get quite high towards the end of the term, so that only a very important patent will be maintained in force for the full term. The next form of protection I'll discuss will be industrial designs. The basic difference between a patent and a design registration is that a patent relates to a particular structure or mode of operation, whereas a design registration relates to the appearance of the article. The design registration may cover the shape of the article, or it may cover some ornamentation applied to the surface of the article. It may not, however, cover any utilitarian feature and must relate only to those features which appeal to the eye alone. In the case of the toothbrush of the factual situation, there might be a structural feature which is patentable, but if not, there may be sufficient novelty in the shape of the toothbrush to obtain an industrial design registration, or there may be certain ornamentation applied to the surface of the toothbrush which could be registered as an industrial design. To be protectable, an industrial design must have a certain amount of originality, but the inventiveness required for design registration is not nearly as high as it is for a patent. At the same time, the scope of protection for design registration is not as broad, and fairly minor variations will avoid infringement. However, the courts generally assess the value of the design, and if it's an extremely novel design, they will give a much broader scope to it than they will where it's merely a minor variation over what was known before. The provisions relating to the time limits for filing design registrations are quite unusual. The Industrial Design Act provides that the design must be registered within 1 year from the first publication in Canada. You'll note here that it must be registered within 1 year, not filed within 1 year. As a general rule, it takes several months after filing before registration is granted, and the time it takes is to some extent not within your control. However, if your client's design has been published and you inform the designs office of the date of publication, they will do everything possible to ensure that your registration issues within 1 year of that date of first publication. Most other countries provide protection for designs as well, and convention priority can be claimed, but in this case, the foreign applications must be filed within 6 months of the Canadian application in order to be entitled to the benefits of convention priority. Applications for design registrations can be filed fairly simply and cheaply. Canadian application merely consists of a drawing of the design and a brief written description. In most other countries, no written description is required, and apart from the formal documents, all that need be filed is the drawing. There's one point to be very careful about with respect to Canadian design registrations, and that is the naming of the applicant. Under the Industrial Design Act, the applicant should be the proprietor. The proprietor is defined in the Act as either the author or the person for whom the author made the design for valuable consideration. Thus, if a design was made by an employee of Company A in the course of his employment, Company A is the proprietor and the proper applicant. However, if before filing Company A assigns the design to Company B, Company B would not be the proprietor within the meaning of the Act, and the application must be filed in the name of Company A, even though the design is actually owned by Company B. If filed in the name of Company B, the design registration is invalid. The other important thing to note is that following issue of the registration, a particular marking must be applied to all articles embodying the design. This marking is set out in Section 14 of the Designs Act and consists of the name of the proprietor, the letters RD, that's a capital R and a small d, and the year of registration. If this notice is not applied to all articles sold after registration, the registration will be invalid. In Canada, the term of the design registration is 5 years and is renewable for a further term of 5 years. Copyright protection, the next form I'll discuss. Copyright protection is available for any literary, musical, dramatic, or artistic work. In the present discussion, I will not consider copyright from the point of view of the entertainment industry, but only from the more mundane point of view of the average small businessman. For him, copyright questions will arise primarily in the field of what are termed literary and artistic works. In the legal sense, a literary work would include any written material in any catalogs, advertising materials, labels, brochures, and virtually any written material of any kind. And artistic works would include drawings and photographs in the same type of material. And copyright will exist in such works despite the fact that there may not be very much artistic merit, provided that the literary or artistic work has at least some degree of originality. Artistic works, or copyright would exist in product designs except for Section 46 of the Copyright Act. This provides that there is no copyright in a design which is capable of being registered as an industrial design and is intended to be reproduced in more than 50 copies. Because of this section, there is generally no copyright in three-dimensional designs, such as the shape of the toothbrush referred to. And if it is desired to obtain a protection for a design such as this, application must be filed to register it as an industrial design within 1 year of the first publication. However, copyright protection is available for other literary and artistic works of the type referred to. And this copyright arises upon the creation of the work without the necessity of complying with any formalities. Anyone who creates a work which is proper subject matter for copyright is entitled to copyright protection therein. There is a procedure for registering copyright in Canada and most other countries, but there's no particular advantage to obtaining registration. I mentioned that copyright arises naturally upon the creation of the work. At one time, this natural copyright was lost upon publication. But under the Berne Convention, to which Canada and most other countries belong, copyright is not lost by publication, and no formalities by way of marking or registration are necessary to to avoid losing copyright on publication. Therefore, in almost all countries, a Canadian citizen is entitled to copyright protection both before and after publication without registering in that country and without applying any copyright notice. There is, however, one rather important country which does not belong to the Berne Convention, and this is our neighbor to the immediate south. The United States does not belong to the Berne Copyright Convention. However, the United States and Canada now both belong to the Universal Copyright Convention. And under this convention, copyright is not lost upon publication, provided that from the time of the first publication, the copyright notice specified in the convention is applied to the work. This notice is a C in a circle, the name of the owner of the copyright, and the year of publication. This notice should be applied to all printed material from the time of first publication, if there's any possibility that it would be undesirable to have it copied by someone in the United States. If the notice is not applied from the time of first publication, copyright is lost permanently in the United States. Next, I'll discuss trade secrets. Trade secrets are also a form of industrial property, and they may be regarded as an alternative to patent protection, where the development is of such a nature that it can, as a practical matter, be kept secret. In the factual example given, the construction of the toothbrush itself would not, of course, be secret once it's put on the market. So if no patent or design protection is obtained, anyone would be able to copy the structure. However, it might be that the process of producing the plastic from which the toothbrush is made could be kept as a secret. And in this case, keeping the invention secret would be an alternative to applying for a patent. There are certain disadvantages to patents. In order to obtain a patent, it is necessary to disclose the invention to all the world, and the patent may be invalid or may be drafted so narrowly that a competitor can make use of the invention without infringing the claim. In any event, the patent has a limited term and will expire someday, leaving it open to all the world to copy. There is also a considerable temptation, there is therefore considerable temptation to keep the invention secret and thereby obtain a perpetual worldwide monopoly. It may be possible where this is advisable and possible, but as a general rule, it is not. In the first place, with modern methods of espionage and the increasing willingness to use them, it is virtually impossible to keep anything secret. And I think some of our American politicians have recently found this to be the case. Also, if no patent protection is obtained, there is the possibility that some party will come up with the same invention and obtain a patent for it. If this happens, that person will have a lawful right to prevent you from using your own invention. This is, in fact, a very common occurrence, and one of the main reasons for obtaining patent protection is to avoid the possibility that you will be prevented by a third party from using your own development. So far, I've dealt with the method of obtaining patent protection for your own client's developments. I think I just might briefly go into what happens when your own client puts a product on the market and what he should do to ensure that he is not thereby infringing the industrial property rights of others. This will be of most concern in the case where your client, to put it charitably, uses his competitor's product as an inspiration for his own development. As far as copyright is concerned, with the exception of items of the type which should be registered as industrial design, there will probably be no doubt but that copyright exists. And the main point is to make sufficient changes in the material to avoid a charge of copyright infringement. In the case of the copying of written material, there's probably no reason why your client should have to copy at all, and he should be encouraged to try to develop something independently. In any event, he should be very careful not to carry over the errors in the material he's copying. It's very difficult to argue that your client obtained the information from an independent source when his material has the same spelling mistakes in it as his competitors. With respect to design registrations, if the required design marking does not appear in the competitor's product, then probably there is no design registration. Or if there is, it's invalid for failure to mark. The only problem concerned here would be whether or not there is a pending application which is not yet issued. If the product has been on the market for more than a year, then no valid design registration can issue. So that if there is no design marking and the product has been on the market for a year, there is no cause for concern. With respect to patents, the problem is a little more difficult. There is a requirement in the Patent Act that patented articles be marked with the words patented, and the year in which the patent issued. But as a general rule, this marking is not applied. More frequently, one sees the designation patent applied for or patent pending. There's no support for these expressions in the statute, but presumably they would be considered to mean that a patent application has been filed but is not yet issued. In fact, it could mean that a patent application has been filed and a patent will someday issue, that a patent application has been filed and no patent will ever issue, or it could mean merely that the inventor has been thinking about seeing a patent attorney but hasn't got around to it yet. People generally talk quite loosely about patents and what is patented. On many occasions, I have seen a client one day and told him there might be some possibility of obtaining patent protection for his invention, only to read in the Financial Post the next week that this man has worldwide patent protection for his invention. As far as patents are concerned, the marking probably has very little significance one way or the other. And if there is any likelihood at all that the item could be patented, a search should be made. The cheapest way to do this, if the company making the item is not one that owns a large number of patents, is to search for patents in the company's name. However, this may not answer the question completely, since the patent could be in the name of some related company or in the name of the inventor, and therefore, to be certain, it is necessary to make a general infringement search in the subject matter in question. Now to get on with trademarks. These are of a somewhat different nature than the other forms of industrial property I've just discussed. And they may well be the type of industrial property with which the small businessman is most concerned. Almost every businessman will have at least one trademark, and this trademark may be a very important asset. Trademarks may be protected by an action at common law or under Section 7B, apart from registration. But it's very difficult to succeed in an action for passing off. And in most cases in which passing off actions are taken, the action is based on a mark or symbol which could have been registered as a trademark. And there is a considerable advantage in registering it as a trademark. I won't go into all of these advantages right now. These are in the written copy, but there are quite a number. I'll just say a word about the procedure for registration. I might just mention one particular problem first, and that is quite common for a company to incorporate under a particular name, and once that name is accepted by the provincial secretary, commence business under the name, only to find that the name is confusing with a registered trademark and that they are not able to use the name. The problem doesn't arise in the case of federal companies because the Federal Companies Department makes a search before granting a company a name, but the Ontario government does not, and therefore before deciding on the name for your company and passing it through the provincial secretary's department, it is essential that you first make a search of the Trademarks Register in Ottawa, which can be done quite simply and will avoid a lot of trouble later on, and a lot of trouble in explaining to your client why this document with a big seal from the provincial secretary does not give him the right to use the name. An application to register can be based on any of four grounds. It can be based on use of the mark in Canada, making the mark known in Canada, proposed use in Canada, and use and registration abroad. Use is defined in Section 4 of the Trademarks Act. With respect to wares, use occurs when the wares are sold in Canada in association with the trademark in the ordinary course of trade. With respect to services, use occurs when the services are advertised or performed in Canada in association with the trademark. It is to be noted that the mere advertising of wares in association with a trademark is not use, and that use must be in the ordinary course of trade, so that it is not sufficient to rely upon a mere token use. With respect to services, advertising is sufficient to constitute use, but it has been held recently that advertising of the mark is not sufficient if at the same time the services are not being performed. The requirements for making known are set out in Section 5, and a mark is made known in Canada if it is used in a foreign country and has become well known in Canada by virtue of the distribution or advertising of the wares. This is available only to foreign residents and is seldom relied upon. A more important ground for our purposes is proposed use. It's possible to file an application based upon proposed use before there has been any use of the mark or any making known. In this way, priority as of the date of filing is obtained, and the filing of such an application would defeat another party who used the trademark before the applicant but did not use it before the applicant's filing date. When an application is based upon proposed use, the application is examined and allowed before any use of the mark, but evidence of use must be submitted before registration will be granted. And the fourth ground, use and registration abroad, is also probably not too pertinent here, but this also enables you to obtain priority without any use. If a foreign company has registered it abroad, he can file in Canada based upon that registration. Again, on the question of examination, I won't go into that now, but the three basic grounds of rejection or possible rejection are discussed in the written copy of the paper. And these are rejection on the basis that the mark is a surname or a name, that it is descriptive of the character or quality of the wares, or that it is confusing with a prior registration. Also, I've gone into the question of generally how to protect marks in foreign countries, including particularly the United States, but I won't go into that. I might just say a few words about licensing of both patents and trademarks. With respect to patents, there are two basic types of license, a non-exclusive and an exclusive. Where a non-exclusive license is given, the patent owner is free to grant licenses to as many different persons as he chooses, and the royalty, as a rule, will be lower than in the case of an exclusive license. In a non-exclusive license, it's usual to include a most favored clause whereby the patent owner agrees that he will not grant licenses to others on better terms. Where an exclusive license is granted, the patent owner may not license others and may not use the invention himself. From the point of view of the patent owner, it is necessary, where such a license is granted, to have terms which ensure that the invention will be used by the licensee on a reasonable basis. This is usually done by providing that if the licensee does not make a predetermined amount of use of the invention each year, then he must either pay the royalty, which would have been payable had he made such use, or the license can be revoked at the option of the patent owner. With respect to trademark licenses, the main point to remember is that it is not generally advisable to license trademarks, and that if a license is made, great care should be exercised to follow the proper procedure. To be valid, a trademark must be distinctive of the owner. Thus, if Company A licenses Company B to use a trademark, and Company B uses that trademark to distinguish his own wares, the mark will become distinctive of Company B rather than of Company A, the owner, and the mark will be invalid. There's a special procedure provided in Section 49 of the Trademarks Act whereby a licensee may be appointed a registered user of a registered trademark by filing an application signed by the owner and by the licensee, setting out the relationship between the two and the conditions and restrictions under which the trademark is to be used. The effect of this appointment is stated to be that use of the trademark by the registered user within the terms of his appointment will be deemed to be used by the owner for all purposes of the Act. It has been held by the courts that where a registered user is operating within the terms of his appointment, the use of the mark by the licensee to identify his wares will accrue to the benefit of the owner for the purposes of distinctiveness. However, this applies only where the registered user is operating within the terms of his appointment. And any use outside of these terms will be use on his own behalf and may result in the trademark losing its distinctiveness and becoming invalid. Some use outside of the terms of the appointment is unavoidable. For example, the marks may be used on wares or services not covered by the registered user appointment, or the owner may not exercise the control provided for in the registered user application. In view of this difficulty, it is advisable to mark the wares with the name of the owner as well as the name of the licensee so that the mark will be distinctive in fact of the owner. This can be done, for example, by marking to indicate that the wares are manufactured and sold by the licensee under license from the owner, naming the owner and the licensee both. So that in any trademark license agreement, and I actually shudder to use the word trademark license agreement because this more or less implies that the mark is going to be invalidated, but in any case where it's necessary to allow by agreement another party to use your trademark, it should be provided not only that the licensee be appointed a registered user before any use of the mark, but also that the wares sold by the licensee be marked in some designated manner that they will remain distinctive of the owner. Just to conclude my remarks, since the time is just about up, I'll say a few words about employer-employee relationships. Probably the main question here is who owns developments made by the employee during the course of his employment. In the absence of an employment contract, the employee may very well own the rights to the invention. Where the employee is hired to make inventions in a particular field, and he makes an invention in that field using his employer's time and using his employer's material and equipment, the invention clearly belongs solely to the employer. When the employee is not employed to invent, and he makes an invention in a field unrelated to his employer's business, on his own time and using his own materials, the invention clearly belongs to the employee. However, there are many situations between these two extremes where it's not quite so clear. Each case must be decided on its own facts, and the possible facts are infinitely variable. However, if the employer does not have the employee sign an employment contract, he runs the risks of losing very valuable property. Many valuable inventions are made by persons who are not specifically hired to invent. And in such cases, the invention probably belongs to the employee. Therefore, good business practice dictates that all employees likely to make inventions should sign an employment contract agreeing that the inventions made during the course of employment, at least those within the field of the employer, belong to the employer. It's just about 10 o'clock, so I think that will conclude my remarks. For those of you who have been fascinated by the mysteries of industrial property, I'd like to point out that on June 7th and 8th, there's a program specifically devoted to patents, a 2-day program. The first day for the general practitioner, and the second day for the specialist. And I understand that there are a few seats still available if you move fast. Thank you very much.
A different comic effect is achieved, much different than with actors.
All right. Gil, if you had a choice of either doing your puppet video show or presenting the entire thing